Good afternoon, ladies and gentlemen of the media and to the listening and viewing public of Trinidad and Tobago. Thank you for coming to this press conference here at the Attorney General's office. I come to speak to you on two important issues. The first issue is to address some of the public disquiet in relation to proposed amendments to the Freedom of Information Act. And the second one is to update you on literally what is hot off the press in the judgment coming out of Jack Austin Warner versus the Attorney General, which was just delivered by the Court of Appeal this morning. I'll start with the Freedom of Information matter. Ladies and gentlemen, it is now public knowledge that the Attorney General's office and the government laid into the Parliament last Friday proposed amendments to several pieces of law. These amendments were put under what is described as a miscellaneous provisions bill. A miscellaneous provisions bill is not an unusual type of legislation. It is legislation which involves tackling the amendment to several laws all at once. If you don't take that course of action, that is to use a miscellaneous provisions bill, then you have to do each and every piece of law one by one and pass them through the House of Representatives and the Senate, and then perhaps the House again, depending upon if amendments are made. That is a very time-consuming process. If you look to our Parliament's website, you'll see that there are umpteen versions of miscellaneous provisions bill. We are 2 weeks into June, and the Parliament goes on its mandatory recess in the second week of July. Therefore, parliamentary space is quite tight, and we have several public holidays upon us. Indeed, there are 2 next week. We had 1 just gone. In those circumstances, the government took the view that we would put together some urgent amendments and we would put those pieces of law into one shot. The Freedom of Information amendments were included in this particular miscellaneous provisions bill. It is clear that what the government considered to be a simple matter was not as simple as the government intended it to be. And therefore, it is useful that we have the kind of democracy that we have, and that I wish to now compliment the media in particular for ventilating an issue as quickly as it did. Certainly, many of the stakeholders in society stepped forward, and those stakeholders expressed concerns. The large aspect of the concern was really in the context of inquiries, whether this was going to trample upon the privilege and the statutory right of freedom of information, because we have a Freedom of Information Act. That Freedom of Information Act provides for public access to public authorities as defined in the law within a particular time frame. The time frame in law, pursuant to Section 15 of the Freedom of Information Act, is that you have 30 days for a public authority to decide whether it's going to give or not give information. The current practice in the Freedom of Information Act and its operation is under a severe attack. And it is as a result of that severe attack that the government took the opportunity to adjust the time frames, to recommend the adjustment of time frames for the reply to freedom of information matters, and secondly, to harmonize how those matters are dealt with. Now, it's very important for us in considering freedom of information for us to understand what the statistics are. The last time a Freedom of Information report was laid, pursuant to Section 40 of that Act, was in 2008. For the period 2009 straight to 2019, the information was not laid in Parliament. This government's failure to lay information was complicated by a full 5 years and 3 months of no data collection by the previous government. And obviously, your reports have to go sequentially. Year on year, you have to file reports. This is not uncommon when we're dealing with the UNC's tenure. At the Ministry of the Attorney General, there were no annual reports filed for the entire time that my predecessors occupied. And we are therefore constrained to finish their reports and then do our own reports. We've managed, however, in terms of statistics, to pull the information forward, and we intend to give the media and give the population the unconfirmed statistical information. Let me confirm that. This is unconfirmed. It's the subject of inquiry right now for the period 2009 to 2016, where we have the most current data. We're processing 17 and 18 as we speak. I'd like to tell you that the freedom of information compliance in this country, the number of yeses that we have, is actually very good. The compliance rate for 2009 was nearly 90% yeses. Of 1,221 applications, only 128 had a no. That 128, in fact, resulted in judicial reviews coming out of 9 matters only. So let me give you that in context. In 2009, 90% of the requests were met with a yes, here is the information. 0.7% of them made it to court. Let me repeat that. 0.7% of them ended up in court in judicial reviews. 2010, the figure was 1,556. That represented the total number of requests. The total number of refusals was 68. That gives you a compliance of 96% nearly. It's 95.62%. That means that there was a yes rate to 96%. Only 7 of those matters, the 68 matters, went to judicial review. In other words, 0.4% of matters ended up in court. For 2012, 3.8% of matters ended up in court. For 2013, 1.2% of matters ended up in court. For 2014, 0.8% ended up in court. Now, 2015 and 2016, we see a very peculiar uptick. 18.6% ended up in court, and 20.8% ended up in court, because the compliance ratios were different. But when we look at the jump in compliance factors, we notice that there's more and more activity in court. It is for that reason that we then went to look at what was actually the situation. Why were we ending up in court? When we looked, for instance, to the Attorney General's ministry, Attorney General and Ministry of Legal Affairs, we've pulled out some information which we'll share with you for the period January 2018 to June 2019. And we've disaggregated that information for time taken to respond to Freedom of Information requests. Of the number of requests that we've received, basically we're at half and half. Half get dealt with within the 30-day period, and another half end up in the period 30 days to 60 days. What we noticed, and in particular what the Attorney General's office noticed in the Freedom of Information realm, is that very often, now let me remind you, the Attorney General has a constitutional role, as you're all well aware, under Section 76 of the Constitution. That rule effectively means that the Attorney General defends or acts for the state in the matters that the Attorney General has jurisdiction over. So if a ministry refuses a Freedom of Information request and a claim is brought for judicial review against that ministry, the AG's office will get involved. It doesn't have to be the Attorney General's office alone. Sometimes statutory authorities also reach out to us and ask us for advice. We noticed an industry that had developed, in particular amongst UNC lawyers, where the state was being milked, fleeced, massive amounts of money for Freedom of Information requests. And in particular, what this scheme involves is filing judicial review applications immediately upon the expiry of time. Having the public authority hand you the information, because they were going to hand you the information anyway, give you the information, you the claimant, and then the attorneys at law, in withdrawing the judicial review applications, demand costs. And let me give you a few examples of what the costs look like. There are a few matters that costs jump out at us on. Let me give you the case of There are a few of them I brought with me here today. I'll give you the case of Daryl Hiralal versus Ministry of Finance. There were two matters concerning Mr. Hiralal. On these occasions, we had proceedings brought. Effectively, the information was handed over by the public authority. And take a guess what the bill was. Two sums were paid. The first one paid was $220,982.01. The next one paid was $209,998.47. So you're averaging about $400,000 for two judicial review matters where the state actually handed over the information. Those matters were properly litigated, but what happened was that the result of the costs awarded against the public authority, we saw $500,000 spent by taxpayers in the circumstances of those cases. Let me give you another matter. Let me put a caveat to this. There are loopholes in this practice because the costs are not fixed. So let me just say that in relation to my situation of stating that the UNC attorneys have been prospering on the back of this, let me put that in very careful measure. This is to be balanced against the fact that there's an exploitation, as is lawfully permitted, which results in costs coming against the state. So let me be fair in this circumstance of saying that the JR applications, the judicial review applications, two matters where the documents were handed over, cost the taxpayers roughly $500,000. Let's go to the case of Vijay Singh versus the Ombudsman. This is an interesting one. Mr. Singh applied for certain information from the Ombudsman, failed to receive, or he asked in March 2015 for information. By January 2016, quite some time later, he submitted a formal request to the Ombudsman. In February 2016, the Ombudsman refused, and the claimant went to court in May asking for judicial review. So the claimant took between February to May to go to court. The requested documents were actually given by the authority to Mr. Singh in November 2016. And for other reasons, the matter proceeded in court. So the documents were handed over, the matter proceeded. The costs in that matter that the claimants are asking for are $1.7 million. Let me repeat that. $1.7 million are being asked for in that matter. Now that matter went to court on A, give me the documents, and B, the court decided that it would hear the issue of whether the Ombudsman was a public authority or not. But that separate issue of whether the Ombudsman is a public authority or not is an issue that actually came to the Attorney General's attention. The Office of the Ombudsman asked me as the Attorney General to be an exempted body under the Freedom of Information Act, and I refused. So as Attorney General, I advised the Minister of Planning, I advised the Parliament, and I spoke to my cabinet colleagues, and I advised that we ought to refuse the request of the Ombudsman to be exempt from the Freedom of Information Act. But that case cost, in terms of claim, the claimed costs are $1.7 million. Let's get to another matter. This other matter is, of course, the now infamous matter of Malcolm Jones and Ravi Balgobin Maharaj. In that particular matter, Ravi Balgobin Maharaj applied for a freedom of information for the discovery of witness statements in the arbitration proceedings where Mr. Chantak and another stepped forward on behalf of Petrotrin and gave evidence. It was that evidence which was held back from the attorneys acting for Petrotrin when an a request for specific discovery was made by the claimant, Mr. Malcolm Jones, the lawyer in that matter, Vincent Nelson QC, with junior counsel as Gerald Ramdeen. The lawyers were called upon, senior counsel was called upon by junior counsel to advise whether these witness statements should be given. The Queen's Counsel said, I have never seen these witness statements. Let me see them. The witness statements were provided and the case collapsed. Petrotrin was told, you don't have a leg to stand up on, and Petrotrin withdrew the case. As Attorney General, since 2016, I informed the public that it was these witness statements that forced the collapse of that case. Mr. Balgobin Maraj went and asked for the Freedom of Information Act to be invoked to get those witness statements. Unbeknownst to the Office of the Attorney General, Petrotrin refused to provide the witness statements. For good reason, they was the subject of arbitration proceedings, but they could have asked for the lifting of the confidentiality provisions and provided the statements. That matter went all the way to the Privy Council. The High Court said no. The Court of Appeal said no to the request, no leave for judicial review. The Privy Council heard the matter, and as a matter of fact, Petrotrin has paid approximately 1 million TT dollars to take that matter all the way to the Privy Council, and Petrotrin is now exposed probably to double that figure for costs that the claimant is going to argue for. So let's conservatively say that you're looking at $2 million in legal costs for that matter. When, as Attorney General, that matter came to my attention, I advised the Honorable Prime Minister of the situation, and as a matter of public record, you are aware that the Prime Minister authorized and instructed that the documentation be provided. That documentation has been provided, but had the Attorney General been given the opportunity to instruct Petrotrin by way of their request of advice, we would have said, under the public interest argument in Section 35 of the Freedom of Information Act, give them the documents. We have one more matter. Singh versus the Public Service Commission. This is a matter that went all the way to the Privy Council. In the Singh matter, we had Mr. Singh making a Freedom of Information Act, 27th January 2016. On the 11th of July, the respondent provided the documents to Mr. Singh. Mr. Singh asked for judicial review on the 18th of July. So let me repeat that. 27th January 2016, Mr. Singh makes a request. The 11th of July, they provide him with some of the documents. 18th July, an application for judicial review is made. 26th July, just a couple of days later, the application is withdrawn. The court awarded a small sum of costs, $7,500. The cost order was appealed and set aside, effectively no orders to costs. The issue of the costs of that judicial review went all the way to the Privy Council, and the Privy Council, in determining what the cost should be, now exposes the state a bill to determine whether $7,500 should have been paid or not. And the Privy Council noted in this position here that the public authority was doing its best to provide it, but that the public authority had failed to demonstrate that it needed more time in a more sensible way. Now, these two latter positions, the Petrotrin position and the Singh position, both of which went to the Privy Council, demonstrate that if we were to centralize the Attorney General's office in considering denials of freedom of information matters, that the state potentially has a fighting chance to save costs. Understand that the figures that we're talking about are 0.7%, 0.4%, 3.8%, 1.2%, 0.8% in the years 2009 to 2015. And therefore, when we're looking at that kind of negligible statistic, those are the matters that actually go to court, we have to now measure those against how much it is costing the taxpayers. Now, the general rules of costs are prescribed by the Civil Proceedings Rules. Part 66 and Part 67 of the Civil Proceedings Rules say basically that the winner gets their costs, and the court has several methodologies to consider how costs ought to be awarded. But in this case, ladies and gentlemen, what is obvious is that if the state had a little bit more time to consider requests and had a centralized mind reviewing the refusals, because it's only the refusals that are being reviewed, and those refusals are bare in number. If we had a centralized mind reviewing those refusals, chances are that you can save the tax-paying dollars. Now, the argument came out commendably that the government should discuss this matter. I accept that the government should have provided information. I accept that I certainly misunderstood the effect that this would have, because perhaps I was too close to the numbers. When I see bare minimal statistics of refusals, less than 1% refusals on average, and when I notice the severity of costs, perhaps I underestimated that the state could easily have persuaded a parliament on the floor once this data was put forward. So let's accept that. It was for that reason that we pressed pause to allow this information to come into the public domain. I intend to give the media this information today so that you can do your own analysis and that you can then extrapolate data for yourselves. I also refer you to the judgments of the court, and I've given you live examples of where the cost of the candle certainly outweighs the cost of the funeral. The baby is being thrown away with the proverbial bathwater. Now, part of the argument that came as to the limits that the bill set, the bill went from 30 days to 90 days additional. So that would have taken it to 120 days, 4 months. It also gave the Attorney General a 3-month period to consider the position. And the argument came that that period is too long. The government has listened to that argument. The government thinks that insofar as there is merit that the period may be too long, that we ought to adjust the time period. And what we have done, and which we circulated to the opposition last night, and the Parliament has disseminated by email to all members of Parliament, is that we have sought to provide a 2-week extension, effectively, beyond the 30 days. So the public authority under Section 15 will move by our proposal, should it be accepted. We're proposing that it move from 30 days to 45 days. I'll just let you know by way of example that Guyana gives you a full 60 days to reply. We have said, let's go for 45 days, having heard what the population has had to say. Secondly, we are proposing, by way of amendments to the bill, that the Attorney General get involved at the moment that the public authority says to the person who's asking for the information, no. So when the public authority tells someone, I'm not going to give you access, or I'm going to delay access, that's under Section 23 of the Act, at that point, the public authority tells the person, you're not going to get it, or it's going to be delayed. We're now saying, let the Attorney General be told as well, at the same time. And we're asking for the Attorney General to conduct a review of that matter within 30 days from that date. So your furthest outside date is effectively 30 days beyond the 45 days. When you look to the cases in court, you will notice that these cases sometimes take years to be decided. If you look to the Ravi Balgobin Maraj case versus Petrotrin, Mr. Maraj applied for the Freedom of Information access in 2016. In 2019, the Privy Council said, we think you have a case to ask for judicial review. They did not say you could get the information, but in 2019, 3 years later, $2.5 million later, if not $3 million later, Mr. Balgobind Maharaj was put in the position where he has to go and ask a court to give him the information. The Attorney General's office instructed by way of its advice, pursuant to the Prime Minister's consideration, that the information should be given, and Mr. Maharaj now has it. We therefore think it eminently sensible that the Attorney General harmonize the pot, be the receiving entity, save the taxpayers some money, and allow for this thing to work in a better, more organized environment. In the public sector, the argument also comes, well, why don't you make it more efficient? Why are you coming to extend the time frame? But ladies and gentlemen, let's accept the state and condition of Trinidad and Tobago right now. Trinidad and Tobago is fighting for its efficiency. We as a government are now implementing things like electronic filing, data management. In this ministry alone, we have scanned and put onto digital record 11 million records. We intend to go live with electronic payments in the month of June. All of this work was not done before. Servers, scanners, etc. So whilst we are improving the systems, we propose take a 2-week extension beyond the 30 days, allow the Attorney General 30 days to review, but the person who applies is put into an active state of waiting because they are told, look, the public authority does not want to give it or is delaying it. Get yourself ready if you want to. Hold on and wait while the Attorney General has a second view of that matter. And that's in essence what our amendments, which are in circulation right now, propose. We accept the recommendations coming from public society that this matter should have been paused, and we did pause it. We were in active consideration in relation to the issue, as I indicated in the public domain. I wish to take this opportunity to correct something. I gave an interview on I-95.5. I can't remember the date, it's all a blur right now. Perhaps it was on Monday. And in giving that interview on I-95.5, I made fleeting reference to a telephone conversation I had with Mr. Gary Aboud. I said that I'd had a conversation with him, I had presented my arguments, and that he had said to me that it appeared to be reasonable. Mr. Aboud went further to say, it may be reasonable for you, put it to the public domain, and let's have a conversation about it. But because we have such excellent hosts at I-95 who were pressing me to go on to the next issue, I didn't have the luxury of time to say all that I did. I note that Mr. Aboud came out quite stridently to say that he never agreed. The quite simple position is I didn't have the opportunity to go into the nitty-gritties of what Mr. Aboud had to say to me, but I want to just correct that lest I leave an impression that is not the correct impression. So under the Freedom of Information Act, our summary position is we believe that the call for pause was commendable. We have taken on board the recommendations which we have been allowed to consider. We have amended the bill in circulated amendments for consideration. These circulated amendments propose that we take an effective move from 30 days to 45 days, effectively a 2-week extension of time. We ask for the Attorney General at the point of the public authority telling the applicant no, or we will delay your position, that you tell the Attorney General but you tell the applicant at the same time. That allows the Attorney General the ability to review the matter. We have included in the amendments that the public authority shall comply with the direction of the Attorney General. If the Attorney General says no, the same remedies and provisions that exist in the law kick in. So there is no denial of right. The statutory privilege of going for a judicial review on the back of a refusal is still preserved. We have only enlarged the time and allowed for a filtration process in the Attorney General. And when you look to the data, which will come to you, you will see that the taxpayers are paying millions of dollars in costs for matters which are, if you look at the numeric factors, 0.7%, 3.8%, some higher figures recently at 20%, but on average, if you took an average from the period 2009 to 2016, you're looking at barely 2% of the matters actually of denials going to the court. We're talking about single-digit numbers that cost us millions of dollars. This abuse of the Judicial Review Act, which surely was not intended, and I should say abuse in the sense of the analogy to tax avoidance versus tax evasion. Tax avoidance is perfectly permitted at law. Tax evasion is not. Let me qualify when I say abuse. I am saying the attorneys that have been involved in this practice have not done anything wrong, but they have caught on to a cow which is giving free milk. And that free milk is the tax-paying dollars. And that free milk now has to be measured for the benefit of the people who are more hungry for the money, which the milk obviously represents. That, in a nutshell, covers the recommendations. We believe that this information can speak for itself, and therefore we propose to return to the Parliament on Friday, this Friday, to volunteer these arguments. We've shared them with the opposition already. The opposition is right now fighting down amendments to the Bail Act. I think that they're standing on their own as we talk serious issues in this country in addition to this. But we thank the stakeholders in the public domain for being vigilant and for raising their concerns in such a quick and forthright fashion. May I turn next, before I turn to your questions, to deal with the matter of Jack Warner and the Attorney General. As you will recall, there is an allegation against a citizen of this country, Mr. Jack Warner, brought in the United States of America, and that matter has found itself with the United States of America asking for an extradition request of Mr. Warner. Mr. Warner is simply required to address the judicial system in the United States of America as to innocence or guilt. I make no statements in relation to that. It would be improper of me to ascribe guilt or innocence one way or the other. The central authority under the Mutual Assistance in Criminal Matters Act is the Attorney General. As Attorney General, I inherited a matter of extradition for Mr. Warner. My predecessors in office were met with an application that Mr. Warner be given the right to be heard in the authorization to proceed process. So when you're doing an extradition, the first step before at the magistrate's level is that the Attorney General signs off on something called an authorization to proceed. My predecessors, the Attorneys General before me, had been in receipt of correspondence from Mr. Warner's attorneys demanding a right to be heard before the issuance of the authorization to proceed. Now, this authorization to proceed issue in our country was settled in the Galbaransing and Ferguson matters. That Piarco Airport extradition request, the law here, as it is elsewhere, settled the fact that you have no right to be heard on an authorization to proceed. That did not stop the ventilation of that matter all the way to the Privy Council and back, which, as you know, took many, many, many years, and those matters are still before the courts. The Piarco Airport was built in 1999 or thereabouts. We're now in 2019. We're talking about a full 20 years that we have that matter going on. On the 7th of September, we had a general election. I met that particular correspondence. I was sworn in on the 9th of September, and I immediately wrote to Mr. Warner on the a couple of days after that. I wrote to him, giving him an opportunity to be heard on the basis that, firstly, there was no right to be heard. I said, if you want to be heard, I will happily facilitate your request, but you must extend the time. Mr. Warner refused to extend the time and did not accept the invitation to be heard. On the 21st of September 2015, I issued the authorization to proceed. Mr. Warner went to the High Court and challenged a particular novel issue. He alleged that the order which Trinidad and Tobago has with the United States was inconsistent with the Act, and he said that the Attorney General lacked the legal ability to give the authorization to proceed. Those arguments were heard before Mr. Justice James Aboud. Mr. Justice Aboud rejected his arguments. He noted that Mr. Warner, whilst he alleged that he needed the right to be heard, did not exercise the right before the Attorney General, this Attorney General, nor did he give a good reason for not accepting it. I'm pleased to say that on the appeal, that matter was heard before the Court of Appeal, and today, June 11, 2019, Justices of Appeal Smith, Musai, and Devines, in a unanimous decision, upheld the decision of Mr. Justice James Aboud. In particular, the judges found that the U.S. treaty had not been shown to lack conformity with the Act, hence there was no merit in Mr. Warner's case that the U.S. order, which declared the U.S. as a declared foreign territory, is not valid. Therefore, pending extradition proceedings in respect of the appellant before the magistrate are valid. The judges go on to say there was no denial of natural justice in the issuance of the authorization to proceed by the Attorney General, and they dismissed the appeal and invited submissions on costs. I'm told by attorneys at law for the Attorney General that the matter has been considered and that they indicated in court, Mr. Warner's attorneys, that they intend to appeal this matter to the Privy Council. I'm warmed by the fact that the Privy Council moves with alacrity in most matters, and that this matter can therefore be effectively treated with in a fairly short space of time. This is, of course, an update which demonstrates to the population that matters can take a very long time in the courts. However, one must persist in the pursuit of the arguments that are volunteered and abide by court decisions. May I now invite your questions, should you have any?
Just break it down for me a bit here now. You said that how the UNC lawyers, therefore, how do they have the current practice, these are your words, under severe attack? So for example, I request information from the Ministry of Health. Under the old system, the current system, 30 days. 30 days expires. How do they then start getting that?
File a judicial review on day 31.
Right.
Get the documents on day 35, as I'm being hypothetical here. Tell you, well, okay, you have to withdraw the judicial review application, pay me costs. In some instances, those costs are as low as $7,500. In some instances, academic arguments prevail over them. In some instances, the withdrawal alone cost the taxpayers $500,000. The withdrawal of the Hiralal matters before the registrar, each of them was for $200,000. So there's a wild range of scale in this argument. And the simple position is, if the public authorities, number one, had a direction of a central mind, in this case we're saying it's the Attorney General, and number two, had a slightly enlarged space of time, we could save tax-paying dollars.
Because you're saying that they found a loophole, and they were abusing that loophole, and these amendments are it.
I'll be fair to say that they weren't abusing the loophole, they were milking the system. You know when you get something free, a legitimate position? Let me explain this to you. Judicial review on freedom of information is what we call cut and paste matters. There's no novelty in these applications. The Freedom of Information form is at the back of the claim form, and the legal arguments and cases are all the same. They're cut and paste, literally. So the cut and paste results in $500,000 today, $1.7 million tomorrow, $7,000 today, and when you aggregate it up, and you just put a flood of litigation on the inside, and you inundate the public system by asking for a volume of information, as the Privy Council, in fact, looked at in the case of, I'll tell you now, the Privy Council looked at this decision in its judgment, which was just recently delivered. It's in the Singh matter. And the Privy Council said it's clear that there was a volume of information to be offered by the public authority, and that the public authority just needed more time. They condemned the public authority for not actually informing. But you see, if we centralize it in the Attorney General, then you can develop a systemized practice. Here is the response. Here's the request for further time. Here is the request for extension of time. The problem in this thing is that all of these public authorities all over the place, each one is doing something different because the Freedom of Information officers are not necessarily in unison in their approach.
All right, now in the amendments you have from 30 days going to 90 days and then 90 days to the office of the AG. You're now scaling that back quite significantly.
Yes.
Why did you go with such a...
Realistically, paperwork takes time. So 90 days in the context of 0.7% and 4%, where you take the Petrotrin matter, Mr. Balgobin Maraj, it took Mr. Balgobin Maraj 3 years for the Privy Council to say, we think you might have a judicial review application to present. 3 years. He got those documents like that from the Prime Minister and from the Attorney General. Had we known about that, we would have said, give him the documents, because the disclosure of those documents demonstrate the fraud that was perpetuated in that matter. That matter should never have come in the manner that it did. So what we're saying here, it's a small statistical number, in most instances below 1% of refusals that go to JRs. But that's costing us a lot of money. So why 90 days? When you go to Parliament, and you may have noticed that as Attorney General, I now take care to say, what I have brought here is a proposal. It's on the floor of the Parliament, or depending upon stakeholder feedback, that we adjust those proposals.
Would it be easier, therefore, to fix the system rather than interfere with it?
Tell me how to do that. No, fix up. No, you see, I want to be careful to acknowledge this, Akash, and I look at your submissions when you put them forward. Very charming, largely comical in the way you present it, but with a nice twist. I don't mean that in a pejorative way. But there is a ridicule of the system. System ain't working, people can't get justice, etc. Whilst we are trying to fix that system in the long-term run, data being converted to digital information, harmonizing practice, etc., that takes some time. In the meanwhile, we have to look at the cost of the equation. Look at the criminal justice system. When we brought in plea bargaining, we were told nobody will ever use plea bargaining. When we brought in judge only, who will use judge only? Nobody on a murder charge would use judge only. You know what happened? That's now history, because those things have made precedent, and case management has now locked in first acquittal for judge only for murder, etc. 400 maximum sentence indicators. Whilst this system slowly moves into performance, whilst the public service is called upon for accountability, because let's be real, you have to manage the issue of performance in the public service in a more efficient fashion. So it is necessary for us, yes, to improve the system, and I can give you an hour on the improvements, but at the same time, if you're seeing costs being pulled out of the system, you have to do something based upon the data.
Adrian, thank you. The consultation. You said that based on media reports and conversations, are you prepared in any way to have a more formal consultation with the people who have asked for it? Because if you look at the newspaper ad, they asked for consultation on this amendment.
At this point, we believe that the data will speak for itself. Because if you were to distill out of the arguments or the concerns volunteered, number one, 90 days is too long beyond 30. Number two, AG having 90 days is too long. If you scale that back to 2 weeks beyond 30, tell the person at the same time and give you 30 days, and you look at it in the context of the data, we don't think that that really deserves too much difficulty. Why? Because we have an 80-90% compliance rate.
Okay, well, let's look at the data a little bit.
Sure.
You said 2010, was it, no, 2009 to 2016.
Yes.
You gave those figures, but you gave percentages. Now, I saw and you noted that in 2016, I believe, and 2015, there was an upward trend in terms of those cases going into court.
Yes.
Is there a reason that you've been able to identify for this upward trend?
Well, if I were to name the lawyers in all the matters that I just gave you, or at least the vast majority, Anand Ramlogan and Gerald Ramdeen.
Okay.
So you got to ask them, and they're skillful enough to take legitimate focus on something that is there for positioning, you know. So let me be fair. As I said to you before, it's not unlawful. It's just being used,
Okay.
quote unquote.
Noting this upward trend, though, is it that there will have to be a separate unit in the office of the AG?
Absolutely. We are establishing a separate unit and staffing it with adequate resources to make sure we are on time there. And let me tell you why. There's a very important case at the Privy Council concerning the freedom of information public interest argument. That's the section 35, that is in the public interest to disclose. It was not the Bal Gobin Maharaj simple JR matter, leave for JR. It's actually the Invaders Bay JCC matter. Remember that matter? Where the Joint Construction Council, Mr. Afra Rehman, was applying for the advice which Mr. Ram Logan was hiding as to how the Invaders Bay land was given away, and they had refused to give the advice, and the Court of Appeal said, give them the advice. Well, we gave the advice. The advice is properly given, which demonstrates that there were serious issues in how that land was being managed. We took the opportunity on a technical issue only. As Attorney General, I instructed an appeal on that case to the Privy Council, not to stop the giving of the advice, but for the Privy Council to settle the issue of what Section 35 really ought to be. When is public interest clicked in? And that matter is going to come up at the Privy Council shortly. And that Section 35 Privy Council decision will help us to settle what our law looks like. In the meanwhile, the Office of the Attorney General, in developing a specialist unit to treat with these matters, will be able to better harmonize all of the approaches. It's already established.
Okay. Go ahead.
In terms of persons, we see that this whole section be closed.
Yeah.
They would say that you have been given yourself a lot of power in terms of, deciding to increase these, but now given the fact that it gets...
So the AG's review. The question is it proper for the AG to review? Yes? Well, I'll turn to the Constitution. The legal advisor to the government of the Republic of Trinidad and Tobago is the Attorney General, with responsibility in certain aspects, certainly for the civil law, and in certain aspects for the criminal law. The Attorney General is the person against whom proceedings are brought. The Attorney General acts in those proceedings, advises the Cabinet, advises the state. So, if the Attorney General constitutionally has that power, and has been doing that since pre-1962, how is that all of a sudden a problem?
Well, exactly, Mr. AG. According to the civil proceedings rules, aren't you also informed when someone intends to go to judicial review? It's already built in there, so I'm asking why put it
Sure.
in the FOIA
Sure.
again?
Because you're informed, and mind you, let me draw a distinction to the argument. Let me be careful, because this is going to be edited into 45 seconds, and I don't know how much time you're going to give it. So let me take the benefit of explaining to those who will write about it. The AG's functionality acts for the state. A public authority under this law includes if a corporation has state funding and controlled by the state. So you may have a limited liability company. Petrotrin, in the Bal Gobin Maharaj matter, would never come to the Attorney General on a freedom of information judicial review. Because the corporate rules, even though they are properly viewed to be a government enterprise, the corporate rules say that they have to handle their own matters. Section 60 of the Companies Act treats with that. Section 99 deals with directors' duties, etc. So it isn't on every matter in the public authority matter that the Attorney General would know about it. And that's one classic example of it. But it cost the taxpayers $2.53 million for that fiasco to have happened.
Let me ask you another question. Now, while talking about that particular case, and as it relates to the witness statements, you said that you took it to the Prime Minister, who authorized that the documents be provided. So it seems to me that a politician can now say that this information, whether it's convenient for them or not, can be supplied to the public. What would have happened if the Prime Minister said no?
then that's why you have a Judicial Review Act. So first of all, it's not a politician. It is a government minister, because not all politicians are ministers. Secondly, when you elect a government, you give them power. You give them power under the Constitution and under statute to do something. And in fact, the common law also gives them powers. So a government is not just any politician knocking from pillar to post. You elected them. Then there are balances to that. If there is a no in this proposed amendment, if the Attorney General says no, take your right of judicial review and let the court tell you what to do. No right is being thrown away, taken away. I was quite amazed by the argument of supposedly learned people to say our rights are being taken away. Your rights are not being taken away. The extension of time came into issue as to whether it was too long effectively. But let any of them stand up today and tell me how the right was being taken away. Nobody can, because we didn't abolish Section 23, which provided the right for judicial review. Come on, that's irresponsible of so many people to have said.
And on the topic of consultation, you're saying no, not now.
What for is more importantly.
Well, you said that the government listened to the argument, but as far as I see, it's just social media commentary and their reporting. Can a government, and the statistics that you just quoted, can a government base a law which is not for just us here now, it's for the future generation?
The answer to that is yes.
On social media commentary?
Well, do you consider that it's just social media commentary? Let me put it to you this way. There may be need for consultation on broader reforms to the Freedom of Information Act. We are not in a space to treat with that broader issue. What we spot right now, there's a big tap that pouring out millions of dollars in costs, and we need to manage that cost. And that's the simple point on this exercise.
So how could you convince me, a member of the public and also a member of the media, that 45 days is sufficient as opposed to the
30?
30 or 90 that was initially?
We'll have to test the data. Left up to me, I would be quite happy with the 90 because there'd be no reason at all why you couldn't do it in that time frame. However, there's a concern that has been expressed by many people that the 90 days is too long. And therefore, you have to take caution in that position. We'll try the 45. If it doesn't work, we'll go there. Let me tell you, it's not the first time we've done something unilaterally, you know. There are two things that you may have missed as the media. Number one, we put an end to the rampant abuse of how costs were paid by the controller of accounts. We amended that law. You don't remember Mr. Ramdeen saying they should call it the Ramdeen Clause in the Senate? Perhaps you didn't notice it. Mr. Ramdeen stood up in the Senate and said they should call that the Ramdeen Clause because we were closing the door on how money was running out of the state, where appeals may have been in process, etc. And the second one that we did that you may not have noticed, the interest rate on judgments was at 12%. We dropped that to 3%. Immediately. We didn't consult on it. We didn't need to consult on it. Do you know why? And you will find this out in the days to come when we reveal certain corrupt activities that will open your eyes. You will understand that there was an industry in obtaining judgments running at 12%. And that corruption will come to the fore soon enough.
Mr. AG, you did say that Ghana, they have a 60-day limit.
Yeah.
Ghana, that's the country quoted.
Yes.
Do you know of any other country of which the Attorney General is also built into the Freedom of Information legislation?
I couldn't say offhand, but I find my comfort in the Constitution. I find my comfort in the fact that as Attorney General, I handle all the civil litigation in my portfolio. I am not only in Parliament passing laws, I manage the Industrial Court, the Equal Opportunities Tribunal, the Commission, the entire Solicitor General's Department, the Chief State Solicitor's Department, advice to Cabinet, advice to all government ministries, and I have acted in umpteen judicial review matters.
Mr. AG, that's you. What about, another Attorney General?
That's any Attorney General. The Office of the Attorney General has done this since prior to our Constitution.
But are you convinced that by inserting the Office of the AG into this act, that there's no way that this law could be taken advantage of.
Let's put it this way. Your worst case scenario is the AG says no.
You go to the judicial review.
So what's the point?
You're saying paperwork takes time. Now, instead of putting the resources into your office, why not strike the FOIA unit?
How do you manage each and every one of the hundreds of public authorities convincingly and in a seamless fashion? How do you manage the hundreds of requests that come at hundreds of institutions on a constant basis, consistently? Do you call them every morning? How many requests do you have? Are you on track? Are you okay? No. What you do is, in the event you're going to say no for 4% or 3% or 2% of the matters, if you're going to say no, tell me if you're going to say no and let me double check you. That's what we're talking about. What could be difficult about that?
Since coming into office in 2015, has your government done anything to strengthen the FOIA units?
As I told you, I could give you an hour on that. You ready for it? Which unit you talking about? Every public authority has a unit. Which one you want to know about? All? Okay. Rest of the media, you all agree?
You could take it myself.
All right. I thought so. Right. Listen, the simple question to you is, what is the mischief? The mischief that we have painted is that there is a discord and disharmony in multiple agencies doing their own thing. There's a direct cost to that. We say that in the event that you get a no, tell the Attorney General, who will review the position. If the Attorney General says no, you have the right of judicial review. You are put upon an active watch. The minute the public authority says no, they tell you and they tell the Attorney General. The Attorney General has 30 days only to review and say yes or no, after which your right kicks in.
AG, just to go back to the detail a little bit. You talked about FOIA compliance being very good, and we're talking about 2009 to 2014 here.
16.
Sorry. Well,
Yeah, sure.
15, 16, upward trend, 18 and
Yeah,
20%.
sure.
So 2009 to 2014. When you say the compliance is very good, is it full compliance? Are these yes?
All right, so
exact 30-day
yeah.
period?
So I'll give it to you. 89.5% yes for 2009.
Is that within 30 days?
Yeah, well, yes is yes. They didn't go to court.
Okay.
95.62% yes in 2010. 95.55% yes in 2012. 87.04% yes in 2013. 95.7% yes in 2014. 73.8% yes in 2015. 83.8% yes in 2016. And let me warn you, that number, that go down of 73% is because there were less matters filed. There were 532 matters filed against the thousands before. So the statistics get skewed. In other words then, 50% of 2 is 1, but 50% of 1,000 is a different figure.
Okay. I'm glad you said that regarding the numbers, the 532, because there is a train of thought that the FOIA process is so frustrating that it discourages people to apply. I myself have experienced it.
As have I.
Right, I've requested information, it takes forever. So I understand that these amendments looked at cost, that abuse that you mentioned, but what about efficiency in terms of the FOIA process? Because in the cases that you mentioned, in all of them, there were responses after 10 months, after 7 months. Shouldn't fixing the problem there at the point
Agreed.
where information is being gathered
Yep.
be part of the focus to reduce costs as well?
Well, you see, you must remember that we're talking as if freedom of information is a simple thing. So somebody rose up and says, listen, I want 20 years of your documents for every check that you have, every receipt, every invoice, every position, etc. And then somebody else rose up and says, look, I want 1 sheet of paper that's on your desk. Because freedom of information is built on the back of what is information and what you're asking for, it's easier said than done. But your point as to improving efficiencies can certainly be improved because you're harmonizing the process. Let me make this clear. One point that perhaps I omitted to make. When the Attorney General is saying no, you're going to get the Attorney General's reasons, That is a powerful thing to have in your back pocket. You will know exactly what the case is going to look like. So you're in a materially advantageous position.
So AG, this specialized unit, so when you talk question, what is your efficiency? This specialized unit under the Attorney General's office, will that treat with those issues?
Yes, yes. They are the review team. Because you know what, we have to, listen, perhaps you don't know, every single file that is in the Solicitor General's department comes to my desk for instructions as what to do. Is it to be settled? Are you going to appeal? Do you agree with the opinion? I spend 17 hours a day on average in this ministry with trolleys and trolleys of books. Gail Alexander is here. Ask her if she doesn't see in her frequent reporting capacity at the Parliament tons of boxes passing to the Attorney General while I sit in the Parliament. They just bring box after box after box of legal work. So the Attorney General, the Office of the Attorney General, requires supervision of the Attorney General personally.
By bringing this FIA under your ministry, how projected, how much money you expect to see?
I couldn't say yet. I'd have to report on that. I certainly could have saved the $2.5 million in the Petrotrin matter. I'll start with that.
Are there agencies such as maybe the Judiciary Service Commission that wouldn't fall under the AG's jurisdiction? Would they still have to follow the same rules before saying no?
The statute provides that all public authorities have that position. There are exemptions to the Freedom of Information Act contained in the exemption orders under that law. I don't have it with me right now, but you'll see as on the amendments to the Freedom of Information that FCB Holdings, FCB Bank, FCB Corporate, FCB Mortgage, Unit Trust, Export Bank, Agricultural Development Bank, TTMF, Taurus, Business Development, NEL, National Entrepreneurship, Central Bank, Integrity Commission, are all exempted. Justice Protection Program, and most recently the SSA.
Okay, and I just want to look at the initial 45 days, that 15-day or 2-week extension. Don't FOIA units now have the ability to request an extension? Because that
You're spot on. The Singh matter, which I told you went to the Privy Council, was a classic example that if they were better organized with formulated responses going out in a timely fashion, we would have avoided that matter going to the Privy Council. So it is the lack of consistency in the multiple bodies that causes this. Somebody should have written and said, look, we intend to comply, we are strictly intending to comply, we require X amount of time frame because it's voluminous documentation, and if you go to court, we reserve the right to use this information against you. In other words, then demonstrating the unreasonableness of the JR request.
Okay, which is why I'm trying to get this clear.
Sure.
Because you've added 2 weeks. Is it 2 weeks for them to still be inefficient and not reply?
Well, the 2 weeks and review. So it's the 2 weeks and review. Because the review is coming to the AG, we intend to disseminate circular information to all of the public authorities, recommending to them that these are the formats for response. Here's your initial reply, prescribed. Here is your I need further extension and reasons why form, prescribed, etc., so that you can get a rhythm and cadence to it all.
Okay, and just something very practical that occurs to me. If someone sends a FOIA request to the Office of the Attorney General, is this 30 days also included there?
Yeah, I have my stats which I'll give you on how many requests we get and don't get.
Fair any legal challenges following the amendments? Because I know the former AG stated that
I really don't take those challenges seriously, to be honest with you. I take the fact of public concern seriously. And I'll tell you why I don't take it seriously. I don't mean to be disrespectful to Mr. Maraj, whom I have good respect for. He's entitled to do what he wishes to do. I'm not afraid of what he has to do. I mean, I'll meet him and address the issues when they come. That really bears little on my conscience or on how I sleep.
Right, so you said that you didn't see a need for consultation for these particular amendments. Will there be amendments coming to make the system more efficient, and will there be consultation on that aspect of it?
You know, we want a whole lot done. Let me tell you what I'm working on as burning priority right now. I've nearly finished my draft of campaign finance reform, which I intend to take to public consultation. I am going to ask the Honorable Prime Minister to consider the mechanisms there. Obviously, I need Cabinet approval to do these things. I am nearly complete with the amendments to the Dangerous Drugs Act to treat with the decriminalization of marijuana. I'm nearly complete with the evidence amendments. There are a whole lot of things that we have to do that we have very little parliamentary space for. The amendments that we propose to the arbitration laws, the significant reforms that we intend to hopefully give you public information on with respect to our courts. There are a lot of burning issues and very short parliamentary time left for us to do that. So I don't intend to do a fulsome overhaul of the Freedom of Information Act. I, at best, can undertake to do certain work, but there's a lot more going on with disabilities, with a whole set of other issues that are really burning issues in our country right now.
So which includes, just want to pivot to this, which includes the increased pensions for MPs and judges.
The retiring pensions, yes.
Let's talk about the timing for that. At a time where society is being told tight its belt, do more with little, why is this also a pressing matter?
Because there are some parliamentarians and certainly some judges that are living in complete indigency. Akash Samaru, you ran a story on Clinton Bernard. You forgot about that?
Who was that?
Good. My point is that the media made a song and a dance quite properly in raising the terrible issue that a retired Chief Justice was living in. It has featured, when I say you, I mean you the media, forgive me. The same way you all say you the politicians, right? The point is, I'm giving you the example of Mr. Justice Clinton Bernard, who served as a Court of Appeal head. And that we had indigency. God rest his soul, Mr. Justice Gaya Prasad lived in some seriously difficult days before his death. There are quite a few other judges there. Now, I'm not saying that wider society doesn't have the opportunity for positioning, but we have a very limited number of persons in these categories. We're not talking 30,000, 15,000, 20,000 people. We're talking in a limited capacity number. And I will not apologize for dedicating, at least for my part, the attention on the judiciary. We are asking for more judges to come in. How are we attracting them to come in if their pensionable aspects are not being treated with? And what we're asking for is that their pension be reset every 5 years into what effectively the current position is.
Why lumping the judges with the politicians, though?
When else will you treat with it? The retiring benefit allowances are in a small category of people there. Listen, I accept that
Politicians also suffering post-retirement.
there are some serious issues with retired politicians. I don't want to call names. People on the UNC bench that served, that have come to my office, that are at the point of death and destitution, looking for money that they can't get from their pensions. Let's accept this. Our country is driven at present by saying that there are certain categories of people that are not to be trusted and not liked. And that's par for the course. The people that occupy the rungs, bottom and second to last, bottom politicians, second to last lawyers. I happen to be both of those as I stand before you now. It's never a good time to tell a politician, let me treat you better. It's never a good time to tell a judge these things. That's our society's position. We then go and we laud societies like Singapore. Singapore is the best and they're performing the best, and Singapore this and Singapore that. And Singapore is paying their politicians $1 million a month, but holding them to very strict measures in respect of corruption and accountability, etc., which you see we are pushing as an agenda on our side. So is it a thorny issue, Akash? Yes, it is. I leave that for the Minister of Finance in particular, that has long pants in this equation, to talk about, because I am a new politician that has served only for a short time. Me personally, would lose little sleep over this issue. But I'm in a different situation from most. Do I make law for myself? No, I don't. That's it. Thank you very much, everyone.